Hello. Hi, everyone. Thank you and welcome. Welcome to the Berkman Klein Center. Thank you so much for joining us today. Before we get started, just a little bit of housekeeping. Thank you. The bathrooms are down the hall and to your left. If you can take your trash out when you go, we very much appreciate it. If you can wait during the Q&A to get a mic, it helps our online audience hear you, and we want to hear your awesome questions. And I think with that, we can start the recording. And I also want to tell you about a technology that we're going to be using today called NextSpace. It is basically an event technology designed by our Applied Social Media Lab, which is right over here. And it helps you kind of take the most advantage of the event. It is here at brk.mn if you're here in the room, /IRL. And if you're joining remotely in our Spy Lounge, it is brk.mn/online. So you can basically kind of ask the event bot any information about the event. So like, hey, I just zoned out. What did they talk about in the last 5 minutes? Some new features include a live transcript. You can also now send a message to the moderator of the event by typing /mod. And you can also give the bot feedback on its messages. So we've used it in a bunch of our events. It's really cool. I very much encourage you to use it. It's running on Cloud Opus 4.5 through the Harvard API proxy. And if you have any feedback afterwards, we would love to hear it at brk.mn/feedback. Okay, thank you again. We really appreciate you all being here. And let's turn it over to our Executive Director, Alex Pascal, and Julie Brill. Thank you.
Hey everybody, how's it going? Happy lunchtime. Really excited for this conversation today. We are very fortunate to have Julie Brill, who has many titles and assets. She's currently the founder of Brill Strategies and an expert in residence at the Harvard Innovation Lab at Harvard Law School. She served as corporate vice president and chief privacy officer at Microsoft, where she led global privacy, regulatory affairs, and responsible AI strategy. Nominated by President Obama, she served as a commissioner of the FTC from 2010 to 2016, and earlier in her career spent 2 decades as an assistant attorney general for consumer protection and antitrust in Vermont, and as deputy AG in North Carolina. So we are delighted to have you here today.
It's wonderful to be here. Thanks so much for inviting me, Alex. It's great.
Most importantly, Julie is an affiliate of the Berkman Klein Center, and we are delighted to have her in our midst for many conversations. Okay, so can you just talk to us, just level set? Can you talk to us a little bit about your career trajectory, how your work evolved from state attorney general's offices to the FTC to Microsoft, and how do these different roles inform the way that you think about governance and data privacy and things like that?
Yeah, well, like I said, it's lovely to be here and to be back. In this room talking to students. I really enjoy it, and I hope you all are thinking about the questions you want to ask towards the end. I've been amazingly blessed with the different roles that I've had an opportunity to play. I began in state AG land, many, many years in Vermont, and then also 1 year in North Carolina. The state attorneys general community, the ecosystem, is an incredible place. A lot of people kind of focus on what happens in Washington, D.C., and misses actually what I think of as the bulk of regulation that happens in the United States, which actually happens at the state level. There's a tremendous amount across every state, and so there's a lot of different opportunities in these different states, not just to work on privacy and digital safety and antitrust. I mean, all of that is true. But then you have sector-specific regulators as well at the state level. I was just able to do a lot. I mean, privacy back then was called consumer protection. And through the consumer protection label, I and a couple of other people very interested and excited about privacy in Illinois and California, we formed a privacy working group for all the state AGs. And that began a lot of the work that the states were doing in terms of investigations around data breaches and whatnot. So it was amazing. I cannot recommend enough to those of you who are thinking about what you want to do when you leave Harvard or wherever you are. I cannot recommend enough thinking very seriously about the state attorney general community. So I did that for, as you said, quite some time. I've been on the planet for a while. When I got to North Carolina, I was only there for a very short time, and I got a call from the White House, and they asked me, this was during the Obama administration, they asked if I'd like to try to become a commissioner, and I thought, gee, that sounds awesome. And it's incredible. I felt like I was drinking champagne and eating strawberries every single day. I mean, it was just the pinnacle of what I had done at the state level for so many years. I'd say that some of the things that I learned between the state AGs and then the FTC was the importance of engagement. I think one of the things that happens at the state AG level, or certainly happened back when I was there, there really wasn't a lot of learning that was taking place between between my team, let's just leave it at that, and companies and what they were doing in terms of technology. But when I got to the FTC, I felt like that was a really important part of my job. And also technological developments were just speeding up. And I thought it was really important to have an open door policy to talk to businesses and to understand what they were doing and why they needed to do it and why they were asking us to do different things or to stop doing things. And it was just incredibly educational. And of course, when you're a commissioner at the FTC, you have that platform that makes it a little bit easier to ask people to come in and explain things. So I thought that was a really important part of what I was doing, was learning and then talking about, in a general way, what I was learning and what was happening. And then I did a short stop at a law firm where I was leading their privacy and cybersecurity practice, a global law firm, and then I went on to Microsoft. And one of the incredible privileges I had both at the FTC and then especially at Microsoft was engaging in global conversations with regulators. I mean, when I was at the FTC, it was regulator to regulator, and really trying to explain how the US system worked during the time of the Snowden revelations and some difficulties that were happening in the transatlantic world. I spent a lot of time in Europe talking to folks in Germany and folks in France and folks at the European Commission in Brussels about what the United States was doing with respect to privacy. And then when I got to Microsoft, because Microsoft is a global company, I really did have to speak to everyone around the world. And again, it was a very humbling and privileged position because the regulators really did want to hear from me and from Microsoft, because we were providing to a certain extent, and do provide, Microsoft, was providing infrastructure to the world and what it was doing and how it was doing it and how it was protecting individuals and being trustworthy. That was something that was really important to policymakers and folks around the world. So it was really, in many ways, each of these roles kind of built on the other, and they all built together to just having a really good understanding of how regulation works at a granular level, at the states and at the federal government, and then globally. And it's been a fabulous ride, really.
Well, it sounds like each role sort of like broadened your horizons and gave you some, a sort of well-rounded view of the different stakeholders involved and how to make it all work.
Absolutely.
Your mention of Snowden gets me thinking of like, wow, those were the good old days of the transatlantic relationship.
Yes. Yes. Although at the time it felt catastrophic.
Yes, I remember.
Right?
Yes.
And so, but we were able to address some of the issues, especially around data flows from Europe, personal data flows from Europe to the United States. Safe Harbor went down, and then Privacy Shield went up, and now the Data Privacy Framework. I mean, these things were developed, but it took a lot of conversation, a lot of empathy, and trying to build something together.
Well, it sort of takes a will, right?
Yes.
Okay, well, maybe that's a great sort of segue. Maybe you could just sort of level set for us, relatively briefly, and then we can dive into the weeds a little bit more. What is the data privacy landscape as you see it in the United States, and how does it compare to Europe?
So there's actually something that has been occurring in the federal-state relationship in the United States around regulation over a fair amount of time, particularly in the privacy space. There's that saying that history rhymes. I mean, that is what I see in privacy. So, for instance, when data breaches were like a big deal, and the state of California went forward with a major data breach law, that was because there was no law at the federal level really dealing with it. There were sector-specific laws dealing with breaches, but nothing that governed companies generally, and certainly not really governing tech companies. So California adopted a data breach notification law, which was really designed to beef up security. It really wasn't about the notifications, but really to get companies to be thinking, hey, they don't really want to have to notify if they have a breach, so let's get our systems in order. And I think it was actually quite effective doing that. That went from one state to all 50 states within about a decade or so, having that kind of law. Now shift over to privacy, comprehensive privacy similar to what you see in Europe through the GDPR. There really is no federal comprehensive horizontal privacy law. And so what do you see? Now 20 states have privacy laws that are comprehensive in some form or another. They're not all the same. They have different flavors. They have different approaches. I mean, I should say there's kind of buckets of them, but 20 different states. And that's really quite remarkable. And I do predict that there will be, on the order of 30 to 40 within the next several years, because some of these issues are so important, particularly when it comes to AI. So you see that, and then now you're even starting to see laws at the state level dealing with AI, which also relates to privacy and data use. So for instance, you're seeing things like, I think there's a total of 38 state laws that touch on AI. The vast bulk of them are very specific. They're focused on specific harms, like deep fakes in the context of elections, or posing as a doctor or a therapist, an AI system posing as a doctor or therapist. Those are the kinds of laws that you're seeing in many states. But there are a few that are developing comprehensive or semi-comprehensive AI laws. So there's three, depending upon how you count, 3 to 5 of those that are going on. So the theme is that the states really don't like a vacuum in areas where they see harms, in areas where they think that there needs to be regulation. So if the federal government isn't going to move forward, you will see state activity. And that's what we definitely saw in privacy and what we're starting to see in AI as well.
And do you think that's because of a sort of a sense of obligation among state leaders? Is that political pressure coming from citizens of a particular state? Like, what do you attribute that sort of like impetus to act?
It's a great question. I don't think it's political in the sense that there's pressure from consumers necessarily. I think what I've experienced at the state is that most state policymakers, those who sit in the state houses, as well as the governor and the governor's staffs, they want to solve problems. I mean, that's what they're there to do. And they'll hear from constituents, or they'll look at data around fraud as an example. And they'll say, oh, we really need to do something about this. And maybe they will hear from, certain members of civil society and certain members of the community and with the business community on both sides or many sides. And they'll recognize that there's an issue that needs to be addressed. And what I found is, I don't want to say that like in Washington, D.C., they don't want to solve problems. I think they do, but it's very, very difficult to get through to reach an agreement in D.C. And this isn't just recently,
It's always hard.
we have not had comprehensive privacy laws or comprehensive AI laws for a while, right? So I really think it's about problem solving. That's my sense, is that, I worked in two very different states, Vermont and North Carolina, and I really felt that the legislatures wanted to move forward, and they almost always found a way to move forward.
That's pretty inspirational.
Yeah. I mean, it's again why I think, I really, do recommend for people starting out, it's actually a remarkable place to work at the state level.
All right, so maybe just real quick, it's hard to do this in the abstract, but I'm curious, how would you think about the division of sort of authority, responsibility, roles among federal regulators, state authorities, the private sector when it comes to governing AI? And how can we sort of think about constructing a regime in which they are complementary actors rather than sort of like conflict engaged? So
turfy. I think that there is a lot of complementary action between the states and the federal government. I mean, when I was at the FTC, I think most of you probably know that there's the FTC Act, and then the states have what are known as mini FTC Acts. So you've got similar or identical words that are being interpreted and used for governance at the federal level and the state level when it comes to consumer protection, competition, and privacy as part of consumer protection. So there's unfair and deceptive acts and practices, and there's unfair competition, methods of competition, methods of engaging in the economy. So the same words, it's a lot of it's complementary work, although sometimes when you've got both the federal government, the FTC or DOJ, looking at an entity or a practice, and then you have the states doing the same thing, there can be discussions about which way to proceed. And those discussions are usually quite cordial, but can also be strong in terms of beliefs about what is the right way to go. So that's sort of a complementary and also can sometimes be a little bit contentious. But generally speaking, I think the feds and the states do work pretty well together, especially in an era and this is not just currently, but it's happened in the past, when the feds take a step back and decide they want to do to be a little bit less aggressive, the states will move forward.
Yeah.
And that that's just what they do. I do think you raised a point about the private sector, and I think the governance that takes place at the private sector is often not part of the conversation around policy and the way in which we govern data. And that's one of the things that I really learned a lot about when I was at Microsoft. It was so eye-opening. There is a tremendous amount of governance that takes place within businesses and in what I call the B2B context. So, and it's not really that visible unless you're either engaged or you know about this through some pathway. But so there's standards. You have not just the business community, but academia and others get together as part of standards groups and really try to form what are the right mechanisms for governance that we want companies to attest to and that we want to become the basis of audits. And ISO is one of the biggest organizations worldwide, has developed privacy governance standards, and now has a very strong AI governance standard. And so companies have the option, they don't have to say we're going to attest to these standards, but in the marketplace there's kind of a demand. Your customers, when you're an entity like Microsoft or Google or AWS or whatever, Cisco, I could go on. You've got customers and they want to know, well, are you keeping my data safe and are you keeping my customers' data safe? And how do I know that? How do you answer those questions? How do I audit that? And the way that happens is often through standards. And again, there's different organizations that develop these, but ISO is probably one of the most important ones. So it's amazing the intricate web of governance that takes place without any regulations. I mean, this is something that is decided among people who really care, who want to make a trustworthy system. They talk about it. Sometimes it takes years to pull this together. And then when it is pulled together, it has a lot of impact in the B2B context, and frankly in the B2C context as well, but also just allowing companies to say, yes, we're trustworthy, yes, we're doing the right thing, here's all the ways that we are conforming with the norms that are expected in this space, whether it's privacy or AI. So I think that that's incredibly important, and in some ways what I think about in terms of this B2B governance system, I actually think it's a new form of checks and balances. It's not regulatory per se, but I've been in the room when very sophisticated customers have come in and said, okay, I want to know what you're doing. I want to see it at a really granular level. And they bring in their best people. We would bring in our best people. And there would be a conversation that sometimes went on for a day, sometimes went on for a week, sometimes went on for months. And these were very sophisticated conversations. And that learning process, that desire of the platforms to understand what is expected of them has, I believe, improved the ecosystem tremendously. Again, this all happens, it's not visible to the outside world, but it's an incredibly important part of the checks and balances that I think allow for a really robust and largely trustworthy tech system.
And so, kind of building on that, how do you think state data privacy laws and GDPR are affecting AI development and deployment in the private sector?
Yeah, I think the privacy laws actually have a huge role in what is happening with respect to AI. So, and this is true. GDPR set the pattern, set the template that is now global, including at the state level in the United States. So you have provisions that require data minimization and purpose limitation. By its nature, thinking about how that works in an AI system is an interesting concept, but I think it is something that, companies think about. How can I use, it's gonna still be a lot of data, but how do I try to minimize the type of data and the amount of data that I'm using? That comes from privacy laws. Thinking about data subject rights, which is, consumers consent, can delete, can access data, incredibly important in the context of training AI. How do you give people a choice of some kind regarding whether their data is going to be used for training or not? I think that comes from privacy, and it is something that the companies are definitely working on. So I think there are provisions like that are very important in the United States because all of those provisions have been adopted by many of the state laws. The one difference between the states and the global privacy GDPR-like laws is whether or not companies need what's known as a legal basis for processing data. Under GDPR and in other places, and so in the EU and then in other places, both within Europe and broader, you need to have a legal purpose that you articulate for why you're using personal data. And the two biggest buckets of those permissions to use data are either you have consent or you have a legitimate interest, which is essentially a balancing test. And that does not exist in the States. And it was a big conversation several years ago, and still is in Europe, about whether or not legitimate interest rather than consent can be used for the purpose of training AI. Because you can imagine, if you're relying on consent, you're gonna not necessarily get as much data as you need for training, particularly when it comes to small societies, small social groups, small languages that aren't, necessarily all over. And that was an argument and a discussion that I had with many regulators in Europe about the need to think about allowing legitimate interest with appropriate guardrails, with the ability to opt out, clear and easy ability to opt out, and other protections, so that AI would really work for all and would really be able to communicate in multiple languages, and really, and it's not just about language, but also idioms, like how do people talk differently and how do they think differently? So that was really important too. So again, it's a privacy rule, but had huge impacts on AI.
So really having me think about sort of the trade-off between privacy and equity.
Yeah.
In some way, shape, or form. Yeah.
Well, yes, you could say it that way. I would have said and did say this is actually a really important part of what legitimate interest ought to be, and you ought to be thinking about legitimate interest because it's so important to be expansive with this important technology.
So more broadly, I mean, you got me thinking about how do you think about sort of data privacy, data minimization purpose in the context of like use of foundation models? Like, is it different than sort of like what we would think of as sort of like an old school or traditional algorithmic system? Should we be thinking about data privacy and data minimization differently when we're dealing with like ChatGPT or potentially like an agentic system? Is there anything different there, or can we just kind of apply old models?
Well, I think,
or how would you even think about that?
Right. I mean, I think that in their language, in their own words, these provisions talk about minimization with respect to the purpose. It has to be proportionate to the purpose. But when you're thinking about building a foundation model, the purpose requires lots and lots of data. So,
and the more you have, the better it is.
The more you have, the better it is, the better functioning it is, and the better it is for humanity, because it is actually reflecting the way people think, the way it becomes more useful in humanity. So you could say that there's a bit of a dichotomy there between calling it data minimization and allowing all this data for foundation models, but the language is, it is purpose driven. And so when you think about the purpose, minimization, maybe a different word should be used, but appropriate, proportionate is really the way that you need to think about it in the foundational model context.
Interesting. So that does flip it on its head a little bit.
I would argue,
Potentially.
There definitely are people who would argue that, no question. I say that one of the many brilliant things about a law like GDPR is it uses very general language. And that general language has been remarkably resilient and a lot of foresight in terms of technology as it expands and as it changes and as new types of technology come in. I would say that the way data minimization is actually talked about within GDPR, foundation models fit right within it because of the purpose.
Okay.
It just requires you really looking at the language carefully.
So that's a great segue to the next question that I had, which is, what do you think the United States can learn from the European experience with data privacy when it pertains to AI and AI development?
Yeah. Well, one thing is, as I said, sort of keeping things really as general as you can. The United States now has many very specific laws, as I mentioned, dealing with deepfakes and elections and licensing and things like that. Those are really important, but if you really want to sort of create a governance system, I mean, luckily the privacy laws in the United States will provide that. But if you want to go broader and have more required governance, you need to think about using broad language because the technology is going to change and new technologies will come around. And I think learning from how GDPR and the Europeans did that, I think would be very helpful for the United States to be thinking about that. If you want a law that will apply more ubiquitously as the tech changes and grows. So I'd say that's one thing. The other thing that is happening in Europe right now, I wrote a piece in LinkedIn about this, but there's a lot of discussion about this generally. Europe adopted a lot of very immersive laws over, let's say, the last 5-6 years. GDPR had been earlier, but you have the EU AI Act, the Digital Markets Act, the Digital Safety Act, DORA. There's a lot of very big laws that were adopted, digital laws that were adopted in Europe. And it's now, and that was in the previous mandate, the previous commission, that the current president, she was president then, and now Ursula von der Leyen in her second mandate, which started, back in September, decided a year ago, she said, we actually need to think about how to harmonize these laws. We've adopted them, they're very important. Now what we want to do is think about how do we make them a little bit easier to comply with? How do we bring them together so that it isn't so complex for businesses that are operating in Europe to comply? So there's a major simplification program going on now. And honestly, I don't remember ever hearing about that in my career, which, as I said, I've been on the planet for a while. I think that it takes a lot of bravery for a government to say, we've done a good job, and it's always good to make sure that what we've done makes sense. And as time moves on, and as we hear from entities that this might be a little complex, to say, okay, let's address that. Honestly, I haven't seen that. Have you ever seen that?
I have not seen that in the United States by and large.
Right.
I mean, you sort of see the complaints and then you get a carve out or some kind of
yes,
sort of blunt force instrument to solve a particular problem. But
yes.
as far as a learning process through
Right.
dialogue, I can't
Right.
remember seeing.
right, and a broad one,
Yeah.
right, to your point.
Right. And humility.
It's humility, but it's also, yes, and bravery. I mean, I really think it is. And so we'll see what the outcome will be. I mean, the outcome might change the way we describe it. But I think that is a remarkable thing that is going on. And I think every country, not just the United States, can learn a lot from that.
Yeah. So based on your experience at Microsoft, how might, or the FTC, your whole career actually, how and when might higher standards of data privacy contribute to better AI for people and communities?
Yeah.
How do we create a race to the top using data privacy?
Yeah. Well, one of the ways is, again, in that B2B world, I think that is what, to a certain extent, what happens. You've got very large customers, the second B in the B2B, who really have a whole ecosystem that they need to answer to, right? Whether it's their employees or their customers or their board, or their regulators, especially in highly regulated industries like healthcare and finance. They've got a lot of stakeholders that they need to answer to. So that process, I think, is a race to the top. It's not a race to the bottom because you have to demonstrate, as the first B in the B2B, you have to demonstrate that what you are providing is deeply trustworthy and will satisfy all of your customers' stakeholders. So I do think that that's really an important element. I also think that one of the things that I saw at Microsoft, and again, I don't know that this is unique to Microsoft, but I can speak to the Microsoft scenarios, was when the immersive privacy laws like GDPR came on board. The only way a very large platform could really ensure that we were complying with it and that our customers could comply with things like data subject rights. How do you make sure that you're pulling, when someone says, I want to see my data, and you've got lots of different verticals, how do you make sure that you're actually surfacing all that data? you have to have technical infrastructure, or Microsoft chose to create technical infrastructure for complying with data subject rights under GDPR. That infrastructure is immersive, it is incredibly important, and it allowed Microsoft to leverage it for the purpose of other requirements around sort of AI and the EU AI Act and some of the other AI laws that Microsoft started to see. Because once you have that core technical data infrastructure, you can use it not just for privacy purposes, you can change the dials on it to focus on training data, making sure you understand the provenance of training data and the permissions around that training data. And if those permissions get withdrawn, you can stop using that data. So not every company can build that kind of, I mean, that's what Microsoft does, is it builds infrastructure. But there are ways, vendors and others that can provide that kind of very robust infrastructure to companies that you can then use. And I think that's sort of the core of trustworthiness. It's not a spreadsheet that you're using to try to answer questions and give people their data, but it's a technical solution. That to me is like the one of the keys to trustworthiness.
Mm-hmm. Right. So if we can drive AI into that trustworthy space through data privacy, that's net win for everybody.
Yeah, through immersive data governance, because that's what privacy and AI share, is the need to have that really robust data governance.
And is there anything you feel like in the landscape, at least in the United States or Europe actually, that you feel like is missing to get us there? Or how would we think about identifying gaps?
Yeah, okay, so one of my pet peeve gaps in the United States is...
You only have one?
Well, this is one of them, yeah. So when I was at the FTC, I was very focused on data brokers. Some of you may know that, some of you can sort of look it up. I had a project I called Reclaim Your Name, and it was about making sure that data brokers, I was urging data brokers to give users more control over their data. So what is a data broker? A data broker is a third party in terms of data use. In other words, they're getting data not because you're engaging with the data broker itself, but you're engaging with other platforms and other parties and whatnot, and the data broker is able to either purchase or obtain data, and then they put it together and they sell it or provide it to others. So that's called third-party data. California has actually pushed on this issue of making sure that users would have control and would be able to opt out of the sharing of data by data brokers or third parties. I think that's fabulous. It's something that I was calling for. I didn't know how to name it. It's called DROP. It's incredibly important, and this is just launching. We will see how much engagement there is with it. But what I regret is that the conversation kind of got focused on third parties and not on first parties. When I think now about problems like differential pricing, sometimes called surveillance pricing, or actually largely called surveillance pricing, sometimes called differential pricing, and other issues involving manipulation of individuals to try to get them to buy things, leaving out first party platforms and first parties in terms of how they can use data, or the ability, or whether you're going to give controls to users about how their first parties can use data, I think is a huge gap. It's a huge gap.
That's a bread and butter issue.
To me, that's absolutely. I think it's a bread and butter issue for consumers. Absolutely. I think one other gap in the United States is right now. It really goes back to the fact that we don't have AI laws except in a couple of states. But I think it will be important as the U.S. builds out laws, is to make sure that you're focused not just on developers, but also on deployers. Now, the EU is a little caught up in that right now with respect to high-risk AI systems. That's going to be paused until there are standards put in place. But a lot of those high-risk deployment use cases are in the healthcare space and in the financial space and things like that. And so it is important to get it right and to get those standards in place first. But I think in the United States, the focus is either very specific harms or foundation models, except in one state, except in Colorado. I think that if you really want to get good governance out there, the regulatory framework needs to think about deployers too. Those that are using AI.
A lot of them.
Yes.
All right, why don't we go to questions from the audience?
Thank you for your comments. I have so many questions. Let me just ask one. If a user withdraws their consent to use their personal data, what happens to models that are trained on that data?
Yeah. In the training space, that does, of course, become hard. I do think what is important is to give the choice before you start the training. There's really, I don't have a great answer other than I think it's important to ensure that that users understand what is happening. The other thing that I think is important to understand is individual data, does not come out from when you're asking for sort of the response to prompts, things like that. Training is a different process of getting the system to understand language and to understand people. I don't want to say there's never a leak, but that's a bug, not a feature of AI. So I do think, when companies start to launch training programs, it is really important to inform consumers, to give them time and space to take action before the training begins. And then also to understand what's really going to happen in the training process versus in the prompt and response process.
So many people saw a Super Bowl ad this weekend where Ring cameras can be used by AI to find dogs. And I thought it was really interesting to see the reaction online where people feel like they have a privacy right in a public space, at least when it involves AI doing all kinds of crazy analysis. So I'm curious if you think actually with the advanced capabilities of AI, people's conception of privacy might be broader, and what you think of that.
It's a really interesting question. Traditionally, I'll focus on the United States for a moment. Traditionally, there's not really a privacy right in the context of the public space. I mean, if you can go all the way back to Louis Brandeis, and he was talking about privacy in terms of private spaces and wanting to make sure that individuals actually had those private spaces. But to your point, I didn't read what was going on online, although I did see the ad. It might get to a place where the use of technology in the public space can lead to what might end up being considered privacy violations, particularly depending upon how the data is used. But that will be I believe, that will be a longer process of adjudication that would be taking place over time. I don't think that's kind of the way we think about privacy, at least in the United States. But it sure was interesting. It's one thing if it's a dog, it's another thing if it's used in different ways, to your point, or to the point that was being made.
Thank you so much. As you may know, the Massachusetts State House is currently debating the Consumer Data Privacy Act, which includes provisions around preventing the sale of location data and also restricting how much data companies can collect and use and sell without explicit consent. And my question is, there's been a bit of a back and forth within the small business community about whether this is helpful or harmful. And earlier in your comments, you talked about your work with small businesses. I'd be curious, what do you think the benefits to small businesses are of a more comprehensive consumer data privacy bill like this one?
It's a really good question. I think that, just like competition between large entities, I think small businesses face the same competition. And if they can say, hey, we're really trustworthy with your data, I think they will have a leg up in terms of how consumers feel about them versus others. So I don't think there's any real difference between small and large in terms of consumer trustworthiness or customer trustworthiness. That said, it can be harder for small companies to comply. I mean, there's no question about that, because they don't often have the ability or really the economic incentive in the absence of these laws to engage and create those kind of systems that large platforms need to do. So I just think that's a reality to keep in mind. That said, I mean, I think that these issues that Massachusetts is grappling with, in the state of Washington, there's the My Data, My Health, which also deals with sort of health data and geolocation, very specific geolocation information. And I do think that these are important issues. But the more granular these laws become, sometimes they can become, you might say, well, they're easy to comply with, but every time a new one is created, it can get harder. So that's why I'm sort of a big fan of the broader general, which have more ubiquitous application. Got a couple over here.
Hi, I'm sure that you're anxiously also awaiting the Supreme Court opinion on the Slaughter case about whether the FTC is going to continue to be an independent agency.
Yes.
And so I wanted to get your opinion on what you think is going to happen / what do you think might take the role if the FTC loses its independent agency authority?
So, Rebecca Slaughter is a close friend of mine. Travis LeBlanc, who's a member of PCLOB, the Privacy and Civil Liberties Oversight Board, was also engaged in similar litigation. There is a thesis around the unitary executive that has been around for quite some time, and this is now what is being tested in these cases. And I think where PCLOB has already been successful in terms of allowing it to be removed from the unitary executive thesis, and where the FTC might have difficulty is with respect to the extent of enforcement that takes place. PCLOB doesn't do enforcement. It's recommendations and reports and things like that. The FTC does those things too, recommendations, reports, 6B studies, things like that. But it also engages in enforcement. And to the extent that enforcement is an executive power rather than a policy power, I think there may be an outcome that I wish weren't going to happen, but will happen. Does that make sense to you? How I'm phrasing that?
Yeah.
Okay.
If users and consumers are given the option whether to allow their private data to be used for training AI, why would anybody ever say yes?
Typically it's an opt-out.
Right, but I'm saying, what advantage would there ever be to allowing it? If you're given the choice,
Oh, sure.
why would anybody ever want it?
So one of the most important things, for instance, in my view, well, actually, I've got a personal example, and then I'll give you sort of the broader example. I think the broader example is, we've got societies in Africa, in Europe, in Latin America, where you have huge populations and small populations that speak very different languages. In Africa, there are hundreds of languages. In Europe, there's, I think it's on the order of 30 official languages, but many, many more. If you want AI to function well for everybody, you have to have those different languages being used for training. And it's not just about languages, it's also about, as I said before, it's really about understanding the way people talk. When they say a certain word, they mean this and not that. Whereas in another culture, it means something different. That's incredibly important for AI to really take off and be the innovative technology that people want it to be, useful for everybody, not just for the majority. You need to deal with these minority groups. And so I think that that's really important. And would I volunteer my data for training? I would, because I know what happens in the system to protect all that. And I know the difference between training and prompt responses and how data is used in those two different contexts. But here's another example. This goes way back. So when I was in the North Carolina AG's office, we were investigating a particular hospital for whether it obtained appropriate permissions from people who were undergoing mammograms, because the mammogram data was being used for the purpose of research and also for the purpose of training various systems. And I was like, okay, this is bad. They're using health data. They didn't get any permission, so I should look into this. I started calling some of the patients. So, do you know that your mammogram was used for research, or the results of whatever test it was used for research? And the response that I got, surprisingly, I was young, but that's why it was surprising. The response I got was, oh my God, absolutely. I want my data to be used. Yeah. I want people to be healthier. I don't want people to have the problems I have. Yeah. So there are going to be contexts and people and that feel that way. Yeah. I do think the important thing is, look, I can't predict the way everyone is going to respond in all of these different situations. The important thing is to give choice.
Thanks.
Mr. Madam first.
And this gentleman also has had his hand up for a while.
I had a couple of questions. One regarding children. I know there's a federal law that's been in the works, the Children Online Protection.
Online Privacy Protection Act, COPPA.
Yeah, that's right.
And COPPA 2.0.
Did a little segment on for a cyber investigation camp for youth a couple of years ago. So I'm curious at the state level if states are encouraging that or working on that. And then when I think about trafficking issues, kidnappings, trafficking, all of that, from a really a global standpoint, and the harmonization that you were mentioning, which I was thinking about when you were mentioning that, can you talk a little bit about how states and feds and global, like Interpol and that whole ecosystem is regulated so that it can move fast for information flow?
Yeah, just to the first question, I do think the states care deeply about kids, and they now, several of the state laws, I want to say maybe half of them, the privacy laws, do consider information about children to be sensitive. And so that data is more protected than other categories of data.
In the whole United States?
Well, there's 20 states right now that have comprehensive privacy laws. And within those, I'm going to say about half or so. Actually, excuse me, that's wrong. Almost all of them consider children's data to be sensitive data, and so it's subject to higher protections. The one exception is California, interestingly, because California has a lot of very immersive laws, but they, if I'm remembering correctly, I don't believe they categorize children as sensitive data at this point. But I do think the states are doing lots of different things around deepfakes and whatnot, as I mentioned, that are going to involve children and whatnot. The NEC system and the Interpol system are incredibly important. I had the team, two different teams. One was around lawful access of data, and one was around digital safety. And so the digital safety team would engage with NECMEC, forgive me, I don't want to misquote what the acronym stands for, but that is the United States' organization that deals with child pornography. And when you have data, when a company is able to detect child pornography, it can report it to NECMEC, and then that information will spread to the other platforms to try to stop the proliferation of that particular image.
It's like a congressionally chartered nonprofit.
Yes.
Which is like, it's a weird structure.
Yes, exactly. It's
missing and exploited children is the last three letters.
National Center for Missing and Exploited Children.
Exactly. So NECMEC is super important. And Europol is also, I mean, there's lots of different organizations, but Europol is also very important. Now, Europol will be more of a enforcement agency as opposed to NECMEC, which is more of a repository, exactly. So what you have with Europol is they want to prosecute people that are engaged in abuse of children. And also you have in the United States, you're going to have, the Department of Justice, or sometimes a state AG, most of which have criminal authority as well. They want to prosecute someone, they have to come to an entity like Microsoft or Google or AWS, whatever, and try to and get data. And then there's a whole process for when and how that will be allowed. So it's a very intricate system. It's been around for a while. This is not new. NECMEC is probably decades old at this point. Europol also very long-standing, and their focus on child abuse and child pornography and CSAM and all of that has been around for quite some time. It's not, again, it's kind of like the B2B world. I mean, these are worlds that are incredibly important, very important in the digital space, very important for trustworthiness around digital. And they work. They just move forward. Could more be done? I don't want to make it sound like all these systems are perfect, but they're very important and they do a lot of good work.
Should I go ahead? Okay. Thank you so much for your presentation. It was really inspiring, very throughout. Thank you so much. But I just want to go back for a second on the comment on opt-out mechanisms. So I come from a European country and I work on artificial intelligence regulation in healthcare. And I really thought that your comment was exactly the opposite of what I was thinking about. So it was really to the point in the sense that you said what pushed somebody to not opt out.
Yeah.
And for me, it's really interesting because the way in which I think about it is that also based on my research is that people, for example, with rare diseases have an incentive in participating and sharing the data because they have a common purpose. But all the rest of people don't have the knowledge, the digital literacy to know that they have a right to opt out most of the time. And the effect of having that mechanism is sometimes very much hidden in the technology. So I see it in the exact opposite. So how do people know that they can opt out, and how can people know that they have that right and can exercise it? And so it's very interesting because I see the balance going a lot on the way of the legitimate interest, but not really on the side of consent, like as in it's a bit of an empty consent.
I understand where you're coming from for sure. I think it's up to platforms and companies to do a good job communicating with their users. This is yet another way in which privacy and AI are similar. Privacy policies are required, and disclosure statements are required under European law as well as, it's good practice in the United States as well. And traditionally, they have been very complex, very long, hard to understand. And I think over time, all sorts of companies have learned how to make it easier to understand, make it sort of easier to grasp quickly what is happening, and maybe more immersive, like high level, you want more information, click here. You want more information about something else, click there. And make it engaging with videos and whatnot. I think the same will happen with AI permissions, but it is up to the companies to make sure that it is good communication. In theory, if it's not, then they will not have passed the legitimate interest test. So, and that gets to another completely different issue, which is the capacity of regulators to really police all of this. I mean, but that's been the case forever. But yeah, I think it behooves companies that do want to be considered, whether they're big or small, that do want to be considered trustworthy, to communicate this in a way that people will understand.
With that, noting that we're just about at time, I'd love to turn it back to Julie and Alex for any closing remarks.
Just to thank you all for being here. This was a fantastic conversation, and particularly to thank Julie for your time and for your insights. It's a pleasure. We're so glad to have you in our midst. And thank you for just enlightening us today.
It's been great. These were great questions, and I'll be happy to stick around for a little bit if your question didn't get answered. But thank you. This has been really fun.
You were bringing up the subject of extremely narrowly focused AI